This is the plaintiff, Dan Berkowitz. He says he rented the defendant's theater for a festival he was having, and she told him she would send out an email blast to help him with ticket sales. There were 5,000 people in her patron base. The defendant failed to live up to her responsibility, and the poor attendance for his festival can be wholly attributed to her. He's suing for $1,875, the money he's owed. This is the defendant, Odalise. She says the plaintiff never provided her with the correct format for the postcards he wanted to send via email blast. She hounded him and his partner for it, but they never got her the materials she needed. She certainly doesn't owe the plaintiff a thing. She's not responsible for his poor ticket sales and isn't going to pony up a penny to the unorganized plaintiff. She's accused of not selling out. The defendant has filed a countersuit for $2,000 for unpaid theater rental and pain and suffering.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff rented the defendant's theater, claims the defendant promised to send an email blast advertising the show, didn't do it, and the show was a bust as a result. The defendant says the plaintiff was a slacker when it came to supplying her with the information to push the event. It's the case of renting from you was not a blast.
Thank you, Douglas. Okay, Dan Berkowitz, doing business as InterArts Creative.
Yes.
You are suing Odalise Nanin and her theater. You've asked us not to mention the name of the theater. We'll respect that, for $1,875 in poor ticket sales that you say are directly attributed to her breaching the contract you had with her. You have a counterclaim against him for $2,000, $1,000 in the price break you gave him, which you want back now, and $1,000 for pain and suffering because you got served with the lawsuit when you were about to perform. What happened?
Thank you, Your Honor. I rented Odalise's theater for the first two performances of a 13-performance gay and lesbian comedy festival, which was going to go throughout the month of June. The two nights at her theater.
This is where?
In West Hollywood and Los Angeles.
Okay.
The two nights at her theater were to serve as a fundraiser for a new not-for-profit gay and lesbian museum, which had just gotten its nonprofit status and which was being announced that weekend. This was to be the first official fundraising event. We had no money for print advertising, so all the publicity was going to be done through email blasts, flyers, postcards, and personal contacts. And one of the nice things about her theater is that the rental agreement calls for the theater to send out 2 email blasts to her 5,000.
Can I see where the rental agreement says that?
Yes. Here's the original.
Thank you, sir.
Okay. Number 2, in all programs, postcards, press releases, and posters, it should say in association with, and then it says the name of her theater, above the title of the show, sample, and then it says the name of your production, which you also didn't want used, sample, show in association with theater must be included in the program. Okay, and then it says down here, in association means you will get 2 email blasts to our 5,000 patrons. Okay, so go on.
Okay. One thing which I perhaps should say right now is that this is the 4th time that I have rented her theater, and each time that's basically her boilerplate. She wants the credit for the theater, but it's really not an accurate credit, and particularly for this, because it was only the first 2 performances of a 13-performance festival.
Wait. That's what your contract says. You just pointed it out,
yes.
So that's what your contract says. I
Right.
mean, it's not really your prerogative to decide she didn't really mean it. Did you really mean it?
Of course I meant it.
Okay, so go ahead.
The only thing which I would say, Your Honor, is that since her theater is geared toward gay and lesbian programming, this was the perfect target audience.
What happened? What went wrong?
Well, basically, we wound up selling fewer than half of the tickets. And when I went to close out the event afterwards, I couldn't find any evidence of her email blast.
Okay, did you do an email blast?
Oh, we did.
How many people did you email to?
Well, several thousand. I mean, each of the committee people did their own list.
Right.
We did.
And how many people can be seated at her theater?
About 250, between 240 and 250.
Is that accurate?
No, it is not. It's 99-seat theater under the equity waiver.
What do you mean by equity waiver?
We're under a showcase.
I don't know what that means. You need to explain to me.
It's just a showcase where actors are allowed, equity actors are allowed to perform on my stage.
But only if there are 99 seats.
Yes, only we have 99 seats.
If it's more than that, then you have to abide by other rules.
Exactly. So it's only 99 seat, my theater.
And how many, what do you say to that?
If I may say, this was not an equity production, and the previous times we were there, we had fit in as many as 125 people.
Your Honor.
What does the contract say about how many seats are available?
I don't believe it actually specifies unless.
Yeah, but how could it not? Because don't you have to have enough seating for the people who show up that day, or?
Well,
how does the contract not say how many seats are available? All right, so what happens? You guys don't do as well as you thought you would, and
right.
there just wasn't the turnout you'd hoped.
Right.
All right, and then you get mad because you find out that she, according to you, she didn't send an email blast, correct?
Right. About a day and a half after the show, as I was putting everything together to give to the museum committee for their archives, I couldn't find any copy of her email.
Had you given her something to send by email?
Well, I know that I sent her what we were sending out in
Yeah, but that's different. If I get an email from you, I don't know that that's what you want me to forward to 5,000 people. I need to know, like, didn't somebody talk to her before and say, here's what we want you to send out?
I don't believe we specifically said it, because it was basically just to say, this is the show playing on this date.
Was that an oversight?
Probably, yes.
Okay, and you wanted to say that...
Your Honor, the producer of the show has to provide a JPEG of whatever he
JPEG
wants us.
JPEG being the format that they want sent out.
Whatever they want us to send out. And it has to say in association with Matcha Theater.
Well, that's what the contract says. What did the material you sent her say? It didn't say in association with?
No, because...
Okay, stop. If it doesn't say, okay, you're the one who pointed out the contract, and in the contract it says in association means you will get to email blast to our 5,000 patrons. And you are admitting to me that you never sent her anything that said in association with.
No, we used in partnership with, which was a different...
Let me see what you gave her, and let me hear from you.
So if the plaintiff didn't supply the information for the defendant to send the email blast out, is the defendant excused from doing it? What do you think?
Yes, I think she's excused from doing it.
Because?
Because she didn't say...
Well, how do you do it if you don't have the information, right?
Well, you can't do it. That's the point.
You can't, you know what? I kind of think that's it, right? You can't do it is the point, and that you're excused from doing it. That's my opinion. That's their opinion. We'll find out what the judge thinks.
What efforts did you make to get something from them in order to send it out to your email blast?
Your Honor, I never received anything.
Did you contact, apparently he's producing this in conjunction with somebody else. He's got a partner.
Right, after I sat down with Mr. Berkowitz and we signed the agreement, the next day I called his co-producer. He told me to call his co-producer.
And why didn't you call him? Why did you call the co-producer?
He told me to call him, that he was the one putting everything together, and he was going to be the one sending me.
So you asked him for the JPEG.
Right, and it has to say in association with.
Right, otherwise it doesn't trigger that clause of the 5,000 emails. So I need to see what it was that was said.
Correct.
Because it couldn't be more specific about the in association with, so let's see. It says where? What did you tell me to look for? Okay,
first of all, in the program, which you have there, highlighted in yellow, it says in partnership with, it's the little Post-it note. Where in the middle of the program, right? Which, according to you, he's supposed to use a certain template for the playbill.
Yes, Your Honor, he did not use the template.
Is that in the contract too? About using the template? Yes, Your Honor, it is. It is. Where? Show me where it is.
The production must follow page 2.
Okay.
I highlighted it for you. The production
give me your copy then, if you highlight it.
The production must follow Matcha's program's template.
Blah, blah, blah. Mission statement must be included in the program. The production must follow the program template, which will be sent to the producer. The playbill, postcard, and poster must be approved before printing. Was it?
No, Your Honor.
Okay, you're out of gas. My verdict in this case is for the defendant. You didn't follow what you needed to follow, and then you actually come to court and sue when you know that nowhere did you follow what you were supposed to follow. I don't understand how you can do that. I mean, you know, what it should be is just a learning, growing experience for you. Next time, follow the letter of the contract that you signed, not me. You have a counterclaim against him for $2,000 for what?
Well, I gave him 50% off, Your Honor, from the rent.
So what?
Of the theater.
Well, how do you now all of a sudden get to charge a full price, a bigger price than what you agreed to?
Well, because I never got the credit, Your Honor.
Well, but there's nowhere in the contract does it say, and if you don't give me credit, you get penalized by an extra grand.
No, it does not.
And
Your
then
Honor.
the other 1,000 is because you got served right before acting.
Before getting on stage, Your Honor.
There's never a good time to be served with a lawsuit.
No,
on your counterclaim, 0. On your claim against her, 0. Good luck, folks.
Thank you, Your Honor.
Hold on right there, please.
Well, maybe the plaintiff can tell us how he cannot follow the contract and then come in and sue after you breach so many so many portions of it.
Well, what didn't come out is that she fined us $200 for what we didn't do, and we feel that that was enough of a punishment that she should have then done the rest of the contract the way she should have.
Mm-hmm. How was the play?
Went very well.
Yeah. Is it going to be shown anywhere else now?
Well, it's actually stand-up comedy, and we'll be doing it again, and maybe at the same venue, maybe another place.
Oh, you would work with her again?
Oh, sure. We just have to be a little more vigilant.
Yeah, follow the contract.
Okay.
All right, head right down this way and come on in here. He says he would work with you again. Would you work with him again?
Yes, he's a nice gentleman. I just think that I don't know what happened. His co-producer was the one that was supposed to follow and bring me the JPEG.
Right. And he didn't hold up his end of the deal.
Yeah, I just wanted him to do what he said and agreed to do, and that's what I expect.
How was his show?
It was good, actually. He had over 70 people in the theater, and I only have 99 seats, so I think he did really good, actually. Yeah.
Harvey?
Okay, well, you know what? The folks behind me are right. I mean, you cannot force somebody or legally bind them to do something that you prevent them from doing under a contract. I mean, if you're preventing them from performing, they're excused from performing. And that will do it for this case. Litigants, for the next case on the way into the courtroom right now.